discussing the Washington Rules of Professional Conduct. Any materials provided by a Washington Civil and Disability Advocate, WACDA, are for informational purposes only and are not legal advice. WACDA is not responsible for the consequences of your reliance on any informational materials provided. Your use of informational materials does not create any attorney-client relationship or any other relationship or the expectation of confidentiality between you and WACDA. The views expressed in informational materials are those of the individual author and may not reflect the views of WACDA or its individual staff members. If you need legal advice, you must seek advice from an attorney regarding specific legal issues. So the principle of client-lawyer confidentiality is given effect by related bodies of law, the attorney-client privilege, the work product doctrine, and the rule of confidentiality established in professional ethics. So we'll go through each of these in turn. We'll begin with the duty of confidentiality. The duty of confidentiality is explained in Washington Rules of Professional Conduct 1.6. The basic premises are that a lawyer must not reveal information relating to the representation of a client. This duty applies to all information relating to the representation, regardless of when or where it was acquired, whether the client asked for it to be kept in confidence, and whether revealing it might harm or embarrass the client. The duty continues to apply even after the lawyer-client relationship is terminated, and it is broader than the attorney-client privilege, which is important to keep in mind as we move through the different doctrines. There are numerous exceptions to the duty of confidentiality. To discuss the important ones, you can disclose information if there is consent or implied authority to do so, if disclosure would prevent death or substantial bodily harm, if it would prevent or rectify substantial financial loss. Disclosure can be required by the court, ethic rules, or law. Disclosure may be necessary to collect a fee or protect a lawyer, to obtain legal ethics advice, or necessary information to address conflicts of interest. A lawyer must make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to a client's representation. The reasonableness of the lawyer's efforts depends on several factors, including the sensitivity of the information, the likelihood of disclosure absent appropriate safeguards, the cost and difficulty of implementing the safeguards, and the extent to which safeguards adversely affect the client's ability or the lawyer's ability to represent clients. I'm now going to walk through a few examples of breach that are a bit more common or overlooked, excuse me. So a lawyer's use of hypotheticals to discuss issues relating to the representation is permissible as long as there is no reasonable likelihood that the listener can ascertain the identity of the client. So it's important to protect the identity of the client and the claims that are connected to them. A second common example is discussing the communications with third parties, so spouses, family members, or inviting the presence of these third parties during confidential meetings. It would be considered breach. So when conducting important meetings with the client in the office, perhaps they should come alone without their spouse, without a family member. It's important to note that the privilege protects the communication between the attorney and then also representatives of the client, so legal assistants, paralegals, etc. Finally, lawyer-client communications made in a public place. The Supreme Court case, Katz versus U.S., discussed that client-lawyer communications are confidential only if they are made in a context where it's reasonable to expect they would remain confidential. So having these conversations in a restaurant is more likely to break confidentiality because it's easy for third parties to overhear privileged information, talking on speakerphone in a public place, versus having these confidential meetings and discussions in an office. Moving on to the attorney-client privilege. This privilege is stated in the Rules of Professional Conduct 1.6, and it's also discussed in Washington Rule of Evidence 502 and codified in RCW 5.60.60 subsection 2. The attorney-client privilege allows a client to refuse to testify and prevent their attorney from testifying in court about communications between the two. The purpose of this privilege is to promote the full disclosure between the client and the attorney so that the attorney can most capably represent the client. The privilege applies to confidential communication made by an individual to the attorney who is sought out for the purpose of obtaining legal advice. We're going to break this down a bit more just because of the nuances of the privilege. So the privilege is limited to communications between the attorney and the parties. A client is a person or entity seeking legal advice or services from an attorney. So someone can be a client, perhaps if they haven't signed an agreement yet. If they're seeking your legal advice and you're having a discussion about legal advice, the privilege applies. Additionally, it is limited to communications between the parties. The next work product doctrine will cover actual work between the parties. Additionally, it does not apply to anything the attorney discovers on their own. The privilege continues indefinitely, regardless of the status of the attorney-client relationship or even death of the client. Additionally, an attorney may not waive the privilege without the client's permission. Finally is the work product doctrine. So the work product doctrine protects documents and tangible items that are prepared in anticipation of litigation by another party or its representation from disclosure to third parties. The main purpose of the document must relate to litigation, and it may be created by any representative of the client. Any client or representative of the client can create work product, and the doctrine only applies when litigation is anticipated or has already begun. Hickman v. Taylor was the Supreme Court case that first recognized the work product doctrine. So to also break this down a little bit, talking about the anticipation of litigation element of the doctrine, this is the proceeding for which the work product was created. This includes adversarial proceedings, such as civil and criminal judicial proceedings, but it can also include arbitration, grand jury proceedings, administrative proceedings. Regarding timing for this doctrine, the work product must have been created at a time when litigation was anticipated. So someone preparing work product must have had a subjective belief that the litigation was a possibility, and that belief must have been objectively reasonable. Additionally, the work product must have been motivated by litigation. So documents do not deserve the protection under the work product doctrine unless their creation was motivated by the litigation and it was created for the purpose of that litigation. In order to assert the privilege, it is not a self-executing protection. So the person who is holding the protection, most likely the attorney, must affirmatively assert the protection. Often this is labeling documents with work product doctrine. There are two main types of work product. The first is fact work product. So this is almost anything prepared by or for a party or its representative in anticipation of litigation. So this depends primarily on the context in which the document was created rather than on its content. A few examples of this type of fact work product might be billing records, a list of confidential witnesses, pictures of a pertinent place that were collected by the attorney. Second, there is opinion work product, and this depends more on the actual content of a particular document. It may include a party's attorney's mental impressions, conclusions, opinions, or legal theories. There are three key matters that are not protected by the work product doctrine. First is underlying historical facts and documents obtained or given to the client. Second is historical facts and documents obtained from or given to third parties. And finally, facts about the creation of work product. To wrap up, we are going to discuss waivers, and it's important to understand how these different privileges may be waived. So first, a waiver is a loss of the privilege or the work product protection from a document or a communication that would otherwise be protected. So waiver may apply to either a particular document or communication or all documents and all communications on a specific topic. There are two different types of disclosure as well, intentional disclosure and inadvertent disclosure. So intentional disclosure, only causes waiver if the privileged communications are disclosed, obviously. Second is inadvertent disclosure. So when there is an inadvertent or accidental disclosure of communications of a document, something was accidentally emailed to the wrong party, the disclosure does not operate as a waiver if three elements are present. First, the disclosure must be inadvertent. It must be an accident. Second, the holder of the privilege or protection took reasonable steps to prevent the disclosure. And third, the holder of the privilege promptly took reasonable steps to rectify the error. So this will most likely constitute emailing the person or entity that was inadvertently disclosed to, apologizing, and requesting that they delete the email, the document, the communications. And that is it. Thank you.